You're 74 years old, and it's a Tuesday morning in March 2026, and you're sitting at your kitchen table in Columbus, Ohio. The coffee is hot, the light is good. On the refrigerator, held up by a magnet shaped like a cardinal, the state bird, the one your daughter gave you when she was 9 years old, hand-painted at a church fair, worth exactly nothing, is a photograph of you and your husband Raymond on your 40th anniversary. He's been gone 4 years now. You still talk to that photograph every morning. Then the envelope arrives. It's from the Ohio Department of Medicaid. The return address is printed in that particular shade of government gray that means nothing good. Your hands shake a little as you open it. Not because you're afraid, because you're 74 and your hands shake now. That's just what they do. Inside is a form labeled MC18-A, Notice of Medicaid Estate Recovery Claim. You read the number at the top, $386,400. That is the amount the state of Ohio is claiming against your estate. That is the amount they say you owe them back for 2 years of nursing home care that Medicaid covered for Raymond before he died. The house you've lived in for 41 years. The house your children grew up in. The house with the cardinal magnet on the refrigerator. The state of Ohio wants that house. You did everything right. You saved. You planned. You thought you were protected. You were not. That is the Medicaid estate recovery trap, and it has been legally, methodically, and deliberately constructed to catch people exactly like you. Raymond and Dorothy Keller maxed their 401k contributions for 28 years straight. They paid off their mortgage in 2011, 4 years early. They drove the same cars for a decade each. They never carried a credit card balance. They had a will. They had a healthcare proxy. They had a durable power of attorney. They met with a financial advisor in 2019 and left feeling confident. They were the model American retirement couple. Then Medicaid reached in. It didn't ask permission. It didn't negotiate. It filed a lien against their $386,000 home the moment Raymond died. It counted every asset. Every dollar they saved was a dollar the state was waiting to reclaim. Every responsible decision they made for 40 years became the mechanism of their own financial destruction. Here is what nobody told you. The financial advisor Dorothy met with in 2019, the one in the navy blazer with the gold pen he kept clicking throughout the entire meeting, never once mentioned Medicaid estate recovery. Never mentioned the 60-month look-back period. Never mentioned irrevocable trusts, exempt asset transfers, or spousal protection rules under 42 U.S.C. Section 1396P. The forbidden truth in one sentence: Medicaid is not a benefit program. It is a loan that your estate repays in full upon death, and your advisor either doesn't know that or isn't paid to tell you. Click the gold pen all you want. That silence cost Dorothy Keller her house. Before we go any further, I need you to do something right now. Hit that like button. Not because it helps my channel, though it does, but because the algorithm actively buries this information. YouTube does not surface videos about Medicaid estate recovery the way it surfaces videos about stock picks and crypto coins. The people who design this system, the government agencies, the long-term care industry, the estate recovery contractors, they benefit from your ignorance. They are literally counting on the fact that this video reaches as few people as possible. Every like pushes back. Subscribe because this channel is a survival archive, not a finance entertainment channel. Not a retirement lifestyle channel, a survival archive. Every video here is a document of what they don't teach you, what your advisor won't say, and what the government hopes you never discover until it's too late. Share this video right now, before you watch another second, because somewhere in your contacts is a person who is 68 or 71 or 74, and they have not transferred a single asset, and they have fewer than 5 years before the blade drops. This is not legal advice. This is a survival guide. Let me show you exactly what happened to the Kellers, with real numbers. Numbers you can replicate for your own situation tonight. In January 2024, Raymond Keller enters a nursing home in Columbus, Ohio. The facility costs $9,847 per month. That is the actual median cost of a private room in a skilled nursing facility in Ohio in 2026. According to Genworth Financial's most recent cost of care survey. Before Raymond enters the facility, the Kellers have the following. Primary residence, $386,400 assessed value. Joint checking and savings, $124,300. Raymond's IRA, $201,700. Dorothy's IRA, $88,500. One 2018 Honda CRV, $14,200 Kelley Blue Book value. Total countable assets, $815,100. Here is the Medicaid math for Ohio. The community spouse, that's Dorothy, is allowed to keep what's called the Community Spouse Resource Allowance, or CSRA. In Ohio, in 2026, that allowance is $154,140, exactly half of countable assets, up to the federal maximum. So Medicaid says, you have $815,100. Dorothy keeps $154,140. The remaining $660,960 must be spent down on Raymond's care before Medicaid pays one single dollar. At $9,847 per month, that spend down takes 67 months. That is 5 years and 7 months of Raymond's savings, Raymond's IRA, and the couple's joint accounts being drained to zero. Watch what happens next. Raymond passes away in March 2026, 2 years into his nursing home stay. Medicaid has now paid approximately $236,328 on his behalf. The state of Ohio files an estate recovery claim the next business day. Dorothy still lives in the house. Under Ohio law, estate recovery is deferred while a surviving spouse lives in the home. Dorothy thinks she's safe. Dorothy is not safe. She is simply deferred. When Dorothy dies or sells the home or moves to her own care facility, the lien activates. $386,400, gone. The house her children grew up in, gone. But it gets worse. Oh, friends, it gets so much worse. Because the IRA, Raymond's $201,700 IRA, was subject to required minimum distributions. When it was liquidated to pay the nursing home, every dollar came out as ordinary income. At Raymond's marginal rate, that created an estimated $44,374 in additional federal income tax liability in the year of liquidation. They didn't just lose the money, they paid taxes on the money they lost. Here is the division formula I want you to write down right now. Total countable assets divided by monthly facility cost equals months until Medicaid eligibility. For the Kellers, $815,100 divided by $9,847 equals 82.8 months of spend down. Now run your own numbers. Add up every asset in your name. Divide by the average nursing home cost in your state. I will link the Genworth calculator in the description. That number tells you how long your family's wealth survives before the government steps in. If that number is frightening, keep watching, because everything I'm about to tell you changes it. Tell me your age. Tell me your state. I read every comment. There are 3 distinct traps inside the Medicaid system. Most financial experts, the ones on television, the ones with the gold pens, only talk about the first one. The other 2 are where the real destruction happens. Trap 1, the spend down guillotine. This is the visible trap, the one that makes headlines when it makes headlines at all. You apply for Medicaid, they count your assets, they tell you to spend down to the eligibility threshold. In 2026, for a single applicant in most states, that threshold is $2,000. For a married couple, it varies by state, but in California, for example, the community spouse keeps a maximum of $157,920. Everything above that line must be liquidated. The guillotine drops. The blade is not metaphorical. Your retirement account, your brokerage account, your certificates of deposit, all of it, gone. Most experts see this trap. Most experts stop here. Trap 2, the 60-month look-back minefield. This is the trap inside the trap. You think you're clever. You heard something about giving assets away. You transfer your house to your daughter in November 2026. You transfer $80,000 to your son in December 2026. And then in 2029, you enter a nursing home and apply for Medicaid. Medicaid pulls your financial records for the preceding 60 months. Every gift, every transfer, every below-market sale. They see it all. And for every $9,847 you transferred in Ohio, They impose 1 month of Medicaid ineligibility. An $80,000 transfer generates approximately 8.1 months of ineligibility, during which you receive no Medicaid coverage and cannot pay privately because you already gave the money away. You are in no man's land, uninsured, in a care facility with no resources. That is the crossfire of the look-back period, and most families walk directly into it because they didn't plan 5 years in advance. Trap 3. The estate recovery lien that quietly bleeds for the rest of your life. This is the one nobody talks about. This is the trap that doesn't announce itself. Raymond dies. Dorothy lives in the house. The estate recovery lien sits on the deed like a silent occupying force, invisible in daily life, present in every legal document. Dorothy cannot sell the house without paying the lien. Dorothy cannot refinance without paying the lien. If Dorothy needs her own care in 10 years, she cannot access the equity in her home to pay for it, because the lien outranks her. Every year she lives in that house, the lien does not shrink. In states that charge interest, and some do, it grows. This trap quietly bleeds for the rest of your life and the lives of your children after you, until one day the house is sold and the state takes its cut before your family sees $1 of inheritance. Who designed this? The Medicaid estate recovery program was not an accident of bureaucracy. It was designed deliberately, codified in OBRA 1993, the Omnibus Budget Reconciliation Act of 1993, and signed into law by a Democratic Congress and a Democratic president who understood exactly what they were doing. Every state was required to implement estate recovery programs for Medicaid long-term care expenditures. The federal government knew that nursing home care costs were exploding. They knew that families would increasingly rely on Medicaid to cover those costs, and they built a systematic, legally enforceable repayment mechanism into the back end of the program, one that activates after death, when families are grieving and vulnerable and often unaware of the lien sitting on the property. The states hired private contractors to administer estate recovery. In Ohio, a private company manages the process. In California, counties administer claims. The contractors are paid on a recovery basis, meaning they are financially incentivized to maximize collections from grieving families. This system captures an estimated 400,000 families per year across the United States. It recovers approximately $700 million annually from estates. That money goes back to state Medicaid budgets. This was not a design flaw. This was not an oversight. This was a feature, not a bug. A revenue mechanism concealed inside a benefit program, activated at the precise moment families are least equipped to fight it. Share this video right now. Someone you know is walking toward this trap today. Same name, same age, same assets, same event. Margaret Chen, age 72, living in Tampa, Florida. Net worth $847,000. She has a home worth $412,000, investment accounts totaling $290,000, an IRA worth $115,000, and checking and savings of $30,000. In January 2026, she receives a diagnosis that her doctor tells her will likely require memory care within 3 to 5 years. Type A Margaret did nothing. She felt healthy enough. Her daughter lives nearby. They'll figure it out when the time comes. Her financial advisor, the one with the gold pen, told her she was in great shape. By 2029, Type A Margaret enters a memory care facility in Tampa at $10,213 per month, the actual 2026 Florida median. Medicaid counts her investment accounts and IRA in full. After the CSRA calculation for a single applicant, her eligibility threshold is $2,000. She spends down $845,000 over 82 months. The home is subject to estate recovery. Her daughter inherits $0. Total preservation, $0. Type B. Margaret sat across from an elder law attorney in February 2026 and spent $5,000 on a comprehensive Medicaid protection plan. She funded an irrevocable Medicaid asset protection trust with her home and $200,000 in investment assets. She retitled her remaining accounts. She made qualified transfers that fell within exempt categories. She started the 60-month clock immediately. By 2031, exactly 5 years later, those transferred assets are fully protected. She qualifies for Medicaid without spend down. Her home is outside the estate. Her daughter inherits $612,000. Not the S&P 500, not an annuity product, not whatever the cousin at Thanksgiving is hyping about indexed universal life insurance. A $5,000 legal plan preserved $612,000 in generational wealth. ROI equals $5,000, $612,000 minus $5,000 equals 12,140%. Bookmark this video, come back to it, show it to your family. Now I'm going to give you the 4 specific assets you need to transfer or restructure before the 60-month clock matters. These are not theoretical. These are mechanical steps with real legal citations. These are the moves that elder law attorneys make for their own families. Asset 1, your primary residence, the Irrevocable Medicaid Asset Protection Trust. Most experts get this exactly wrong. They tell you to deed the house to your children. Do not deed the house to your children. A direct deed transfer is a countable transfer under the look-back rules. It creates immediate gift tax reporting obligations. It strips you of the stepped-up cost basis protection under IRC Section 1014, and it exposes the home to your child's creditors, divorce proceedings, and estate. That is not a plan. That is a trap with a different name. The correct vehicle is an Irrevocable Medicaid Asset Protection Trust, sometimes called an IMAPT. You transfer the home into the trust. You retain a life estate, meaning you live in the home until death, you maintain the homestead tax exemption, and you preserve the stepped-up basis for your heirs. The home is outside your countable assets for Medicaid purposes after 60 months. It is outside your probate estate. Estate recovery cannot touch it. In Florida, this structure is authorized under Florida Statute Section 736.0505 and must be drafted carefully to avoid the settler trust exception that would pull assets back into Medicaid countability. In Ohio, the trust must comply with ORC Section 5816, the Qualified Dispositions in Trust Act. In California, Medi-Cal's expanded definition of assets available requires specific language to establish that the trust is truly irrevocable and beyond the applicant's control. Mechanical steps: retain a licensed elder law attorney, execute the trust instrument, transfer title via a new deed recorded with your county recorder's office, notify your homeowner's insurance carrier, and notify your mortgage servicer if a mortgage exists. The entire process takes approximately 30 to 45 days. Instead of losing her $412,000 home to estate recovery, Dorothy Keller pays $3,800 in legal fees and retains it permanently. Asset 2. Non-IRA investment accounts, strategic spend-down and exempt conversion. Most experts get this exactly wrong. They tell you to preserve your investment accounts as long as possible. For Medicaid purposes, preservation without planning is destruction in slow motion. Under 42 U.S.C. Section 1396 PD, certain asset conversions are recognized as non-countable. You can convert countable liquid assets into Medicaid-exempt assets without triggering transfer penalties. These include home improvements, prepaid irrevocable burial contracts up to the applicable state limit, accessible income-producing property, and in certain states, annuities that comply with the Deficit Reduction Act of 2005's annuity rules under 42 U.S.C. Section 1396P C1G. In Florida, a Medicaid-compliant annuity can convert a countable asset into a non-countable income stream, provided it is irrevocable, non-assignable, actuarially sound, and names the state as primary beneficiary after the community spouse's death. In Ohio, the rules are similar, but the state recovery rights are more aggressively enforced, so timing and sequencing matter. In California, Medi-Cal applies different annuity rules, and the Attorney General's office actively scrutinizes DRA-compliant annuity arrangements. Mechanical steps: obtain a current account statement for all non-IRA investment accounts, calculate the Medicaid countable total, consult an elder law attorney about exempt conversion options specific to your state, execute the conversion in writing with a OBRA DRA-compliant annuity provider, if applicable, and document all conversions with dated signed records. Instead of liquidating $290,000 in investments to pay the nursing home, Type B Margaret converts $180,000 into a Medicaid-compliant structure and protects it from spend-down. Asset 3. The IRA, the most dangerous asset in your estate. Most experts get this exactly wrong. They treat the IRA as untouchable, the crown jewel of the retirement portfolio. For Medicaid and estate purposes, the IRA is the most dangerous asset you own. Here is why. Under current Medicaid rules, an IRA in payout status, meaning required minimum distributions have begun, may or may not be considered a countable asset, depending on your state. In Ohio, an IRA in RMD status is counted as an income stream, not an asset. In Florida, it depends on whether the account is accessible. In California, it is generally counted as a resource. But here's the trap within the trap. Under Secure Act 2.0, PL 117-328, most non-spouse beneficiaries must now fully distribute an inherited IRA within 10 years of the original owner's death. Every dollar distributed is ordinary income. If your child inherits a $200,000 IRA, they pay income tax on every distribution, potentially at rates of 22%, 24%, or higher, depending on their own income, over 10 years. The IRA your family spent 30 years building gets a 24% haircut on the way out the door, on top of whatever Medicaid spent down during your lifetime. The solution is a Roth conversion strategy executed strategically in the years before Medicaid eligibility becomes relevant. Under IRC Section 408A, converting traditional IRA funds to a Roth IRA generates taxable income in the year of conversion, but the resulting Roth account produces tax-free income for heirs, is not subject to RMD rules during the owner's lifetime, and in some states is treated differently for Medicaid asset calculations. Work with a CPA and elder law attorney together. This is not a solo move. Instead of losing $44,374 to income taxes on a forced IRA liquidation, Dorothy Keller executes a staged Roth conversion in 2022 and 2023, pays $18,200 in taxes at a controlled rate, and her daughter inherits the remaining balance entirely tax-free. Asset 4. Qualifying gifts to family, the annual exclusion strategy done correctly. Most experts get this exactly wrong. They hear annual gift tax exclusion, and they think it exempts the transfer from Medicaid lookback. It does not. The IRC Section 2503B annual exclusion, currently $19,000 per recipient in 2026, is a gift tax rule. It has absolutely nothing to do with Medicaid transfer penalties. Nothing. These are two completely separate bodies of law, and conflating them is one of the most common and catastrophic mistakes families make. That said, gifts to family members can be a legitimate part of a Medicaid protection plan if executed with precise timing and proper documentation. Under 42 U.S.C. Section 1396 PC2, certain transfers are exempt from penalty. Transfers to a spouse, transfers to a blind or disabled child, transfers to a sibling who has an equity interest in the home and has lived there for at least 1 year, and transfers to a caregiver child who has lived in the home for at least 2 years and provided care that delayed institutionalization. In Florida, the caregiver child exemption is one of the most powerful and underused tools in elder law. A child who moves in, provides documented caregiving for 2 years, and receives the home as a transfer faces no Medicaid transfer penalty, regardless of the home's value. In Ohio, the same exemption applies, but documentation requirements are rigorous. Physician certifications, care logs, and evidence of delayed institutionalization are all required. In California, Medi-Cal applies the exemption narrowly, and the documentation standards are the most demanding in the country. Mechanical steps. Consult an elder law attorney. Document the caregiving arrangement in writing from day one. Obtain physician letters confirming the care-delayed nursing home placement. Record the transfer via deed with proper legal description, and file the required gift tax return, even when no tax is owed. Instead of losing her entire home to estate recovery, Dorothy Keller transfers the property to her daughter Sarah, who moved in 2 years ago and provided daily care under a fully documented caregiver child exemption. Zero penalty, zero recovery. The house stays in the family. The clock is ticking right now. Today is May 15th, 2026. The 60-month Medicaid lookback period means that any asset you transfer today, this Tuesday, this exact date, is not fully protected until May 15th, 2031. That is your deadline. That is the date your protection strategy either works or it doesn't. 5 years from today. There is no version of this where waiting helps you. Not one. If you wait 6 months, your protection date moves to November 2031. If you wait a year, it's May 2032. And every month you wait, the probability that a health event interrupts your timeline increases. A stroke does not respect your planning calendar. A fall does not care that you had an appointment scheduled for next spring. Tonight, before you go to sleep, get a notebook, not a spreadsheet, a physical notebook. Write down every asset you own and its approximate current value. Write down your state of residence. Write down the names of your children or intended heirs. Write down whether you have an existing will, a trust, a power of attorney, and a healthcare proxy. If you can't fill in all 4 of those last lines with a confident yes, you have work to do immediately. Dorothy Keller, in this story, did the planning. She sat with an elder law attorney in February 2026. She funded the IMAPT with her home. She documented her daughter's caregiving. She started the clock. By May 2031, her $386,400 home is fully protected. By 2035, less than 9 years from today, her family retains generational wealth instead of surrendering it to a government recovery contractor. Over a 20-year horizon, for a family with $800,000 in assets, the difference between planning and not planning is not $386,000. It is $1.4 million in preserved and compounding family wealth. That is the cost of a Tuesday afternoon with an elder law attorney versus the cost of trusting that someone else would tell you. No one was going to tell you. That is why you are watching this video. Here is what I need you to do right now. Not after dinner, right now. Hit the like button. The algorithm buries this information deliberately, and every like is a small act of defiance against a system that profits from your family's ignorance. Subscribe to this channel, because this is the video your parents needed 10 years ago, and there are 12 more videos in this library that your family needs this year. Leave a comment below with your age and your state. No personal details, just your age and your state. I read every single comment. I respond to as many as I can. And when I see patterns, when I see that 74-year-olds in Ohio are all asking the same question, I make the next video about exactly that. Now send this video to one person today. Not tomorrow, today. You know exactly who needs to see this. There is one person in your contacts right now, a parent, a sibling, a friend who mentioned nursing home costs at Thanksgiving, who is walking toward the Medicaid estate recovery trap without knowing it. One share, one message. That is how this information defeats the suppression. Medicaid estate recovery captured 400,000 families last year. It will capture 400,000 more this year. The contractors are hired. The liens are drafted. The system is patient. It does not need to rush. It waits until your parents are gone and your family is grieving, and then it walks up to the house you grew up in with a legally enforceable claim, and it